held on 8th August.
It's one of the more complicated relationships within the Kenyan government.
Tunauliza kila saa, kila pahali tukienda. Jaji amesema, tunafanya kazi hii, unakuja una block, unaweka injunction. Kwa hiyo unafikiria wewe umechaguliwa na nani? No, there's a problem and we must fix it.
And it has been so historically.
Katiba ya Kenya ni ile itakayolinda wewe, na linda mimi, na linda watoto hawa. Kitu gani? Why do we differ?
Now, the Building Bridges initiative has birthed proposed constitutional amendments that may complicate the relationship between the executive and the judiciary even further.
I did some more reading. Let me start there.
The Constitution of Kenya Amendment Bill of 2020, which will possibly send Kenyans to a referendum, has several proposals that touch on the judiciary and key judicial offices. Our constitutional experts explain the legal implications of introducing a Judiciary Ombudsman appointed by the President, changing the constitutional tenure of key judicial officers, and adjusting how the National Police Service promotes police officers. This proposed new article to the Constitution, 172A, caused ripples as soon as the amendment bill was made public. It proposes the establishment of an office of the Judiciary Ombudsman. The proposal states that the President shall nominate and, with the approval of the Senate, appoint the Judiciary Ombudsman, whose role will be to receive and conduct inquiries into complaints against judges, registrars, magistrates, and other judicial officers and other staff of the judiciary, sensitize and promote engagement with the public on the role and performance of the judiciary, and improve transparency and accountability of the judiciary. This person will also be an ex-officio member of the Judicial Service Commission and will have the same qualifications as a judge of the Supreme Court.
The Judicial Ombudsman will be an ex-officio member of the JSC. When the JSC moves to investigate a judge, under the current constitution, they move of their own motion. Now, there's a proposal that their own motion or the Judiciary Ombudsman, and remember the Judiciary Ombudsman can receive complaints about anyone.
Right.
So that means...
Including a Supreme Court judge.
Exactly. So that means the Judiciary Ombudsman can receive complaints from the public to do with the members, with the substantive members of the JSC. Mm-hmm. And so can at any point in time decide that they are investigating the CJ, which I'm not saying it's a bad thing, but it would be very disruptive, because one of the things that happens in this country is that we've seen situations where whenever the judiciary makes decisions that either the legislature or the executive isn't happy with, there's always somebody who runs off and wants the Chief Justice removed. Now imagine the Chief Justice having to deal with that person being in there, in the JSC, and then this person not only wanting the Chief Justice removed, wanting all the other members of the JSC, such as the President of the Court of Appeal, all the other representatives who are judicial officers.
Kenya's judiciary has limped through the country's history. Imperial presidencies, like that of the late Daniel Arap Moi, undermined the judiciary's independence. The courts were underfunded and easily corruptible. But that changed under the dispensation of the Constitution of Kenya of 2010. Even so, the current executive's relationship with the judiciary has also been strained. President Uhuru Kenyatta, for instance, blew hot and cold when the Supreme Court annulled the 2017 presidential election, which had gone in favor of Kenyatta. On one hand, he upplayed diplomacy despite being disappointed by the court's decision.
I personally disagree with the ruling that has been made today, but I respect it.
But on the other hand, he issued this rather haunting warning.
Na tukishamaliza, tutarevisit hii mambo yenu.
While the history is important to understand the implication of having the Judiciary Ombudsman as proposed, other proposed amendments offer deeper context to this discussion. Alongside the proposal to have the Judiciary Ombudsman, who can receive complaints on judges, the amendment bill also proposes to change the tenure of senior judicial officers. It proposes amending Article 165 of the Constitution to limit the tenure of a High Court judge to 5 years. It also proposes that the Chief Justice must have 20 years' experience as a Superior Court judge instead of 15 years, and that a Court of Appeal judge must have 15 years' experience instead of 10.
This is actually a very, very powerful office. And already there are mechanisms for investigating judges for whom there are questions about their conduct. Judges are state officers, so just like everybody else, they're subject to Chapter 6. There's already a mechanism for the removal of judges who've been engaged in corruption. Judges are not immune to investigation by the EACC. So why do we need an extra accountability mechanism specifically just for judges?
And the mischief here is that the president, when you look at it's what Atango was alluding to earlier, before even we came in categorically to this. Now we have the president nominating. This is somebody. The only thing they have changed, I think, between the first bill and this one is now, say, with the approval of the Senate. You know, it's a way of getting the president inside the judiciary. So with the purported creation of a parliamentary system with that prime minister, that is the Trojan horse for the president to get into parliament. And with this judiciary ombudsman, that's the other horse for the president to get into the judiciary. Because, as you asked, is it that the current judiciary ombudsman has not been performing as should be?
There's yet another layer added to this debate. The constitution of the Judicial Service Commission, an independent constitutional commission which plays key roles like recommending people to be appointed as judges, reviewing conditions of judges and judicial staff, and the very important role of receiving complaints, investigating, and removing from office magistrates and other judicial staff. Currently, under the Constitution of Kenya of 2010, the JSC is made up of the Chief Justice, who chairs the commission, one Supreme Court judge elected by the judges of the Supreme Court, one Court of Appeal judge elected by judges of the Court of Appeal, one High Court judge, and one magistrate, a man and a woman, elected by the members of the Association of Judges and Magistrates, the Attorney General, two advocates, one a woman and one a man, each of whom has 15 years' experience, elected by members of the statutory body responsible for the professional regulation of advocates, one person nominated by the Public Service Commission, and one woman and one man to represent the public, not being lawyers, appointed by the President with the approval of the National Assembly. The last two members, as well as the Attorney General, would all have joined the Judicial Service Commission through the executive. So with the proposal to have the Judiciary Ombudsman sit in this commission, the President would have at least 4 appointees at the JSC.
So you have the risk of a JSC that is actually controlled by the executive. Okay? Then you now start to move away from the very elaborate system for the removal of a judge. Because security of tenure is very important with respect to judges. Judges need to have the confidence that they can't be removed willy-nilly. To now, suddenly the JSC, the newly reconstituted JSC, suddenly has more powers vis-a-vis the removal of judges.
Right.
Yeah.
So they can suspend a judge.
Yes.
And this judge they've been investigating.
And remember,
it was recommended by the ombudsman.
By the ombudsman.
we have seen several judges. You've seen petitions taken to the JSC, some weighty, some mischievous, but still there's a process, a due process that they are taken through. So what has failed with that for us to now say we need that Judiciary Ombudsman to be one appointed by the president? And that's why we read mischief in this, because I keep saying we cannot also look at this document as if we came from Mars yesterday. We must look at our history and our immediate experiences and the politics that have been going on around the current executive and the judiciary.
Bobby is referring to moments like these, where the former Chief Justice David Maraga and President Uhuru Kenyatta clashed publicly.
Justice David Maraga has decided to take the head of state head-on after what he termed a failed attempt to secure an appointment with him.
Some CSS and the PSS are bragging that the CJ will or should be removed before the end of this year. Really? Kumbe hii nchi kuna wenyewe. Some of us are serving at their pleasure.
Mimi nataka niwaambie wenye koti, tumewaheshimu, lakini msifikirie heshima ni uoga.
Is there a possibility of still maintaining separation of powers if these proposals sail through?
That possibility has been greatly muddied. You know, that space is greatly shrinked, particularly because we also have a history where, as it is, we have a parliament which, despite us having a presidential system, has somehow not been able to assert itself vis-a-vis the executive. You know, they have behaved as if we were still in the old hybrid system.
Number 35 and 36, they talk about the Director of Public Prosecution. And first and foremost, they want to amend Article 157(3) to try and ensure that the DPP's qualification is that of a Court of Appeal judge and not a High Court judge. Is this a positive proposal, that perhaps we have a more experienced DPP?
Remember, also under number 39, they're increasing the number of years. So what it tells you, first of all, is that the next DPP, if this goes through, will have to be an older person because they will have to have had, I think, 15
years as opposed to 10 years.
Supreme Court is 20.
Yeah.
15 years of experience.
Right.
So already what it means is that there's already a whole class of people that would be eliminated from the office.
So someone like the current DPP wouldn't have met this threshold?
It's possible. He might not have.
Okay.
Yeah. You know, so it's, you know, which to me, again, it just shows you, with all due respect, I think he's probably been the most visible DPP we've had. You know? And has been, I don't think if one was to analyze the performance of various DPPs, he probably would emerge as one of the most effective in the history of the country. But he may not have qualified if this was in place.
This is even more interesting because number 36 proposes the repealing of Article 158. And Article 158 talks about removal and resignation of a DPP.
Yeah, it worried me. I looked at it and I wondered whether or not it was an attempt to remove his security of tenure. Because remember, originally the DPP used to be in office in the Attorney General's chambers. And it is only after this constitution came into effect that the DPP became an independent office. Then I noticed there's another amendment that is later, which seeks to include the DPP in independent offices.
offices.
Yeah, and so
Is that a check and balance that now we've made the DPP an independent
We may have taken
office?
away but he already was.
Right.
The only difference is that the independent officers that are listed there, it's because somewhere in the body of the Constitution, their terms of office are not spelled out. So there is need to place them under the omnibus terms of office for independent officers and commissions. So why would you move from the specific terms that exist for the DPP to those? And it's one of those things I just didn't have enough time to interrogate. Yeah. So I don't know if, Bobby, you saw it and then, if you looked at it.
No.
Initially, my fear was that there was just nothing in place for resignation and removal.
Yeah, that's what I wanted.
And removal is very important in terms of security of tenure. And so one would need to really look a little bit more closely and see whether or not the general terms for removal for other independent officers are just as confer the same kind of protections to that office that the specific terms that exist currently under
158.
Under 158.
Because when I read Article 158 of the Constitution, it appears very elaborate.
Exactly.
Very elaborate about the removal of or resignation of a DPP.
Because one thing I noticed yesterday when we were, it occurred to me again when we were interrogating the issue was the Judiciary Ombudsman. And the fact that apart from prescribing that the office holder shall hold office for a non-renewable 5 years term, one term, but there was nothing to indicate how the person could be removed from office before termination of or expiry of the 5 years term. Meaning this is left to the
discretion.
Discretion of the appointing authority, which is the president.
So would that also be the case for the DPP if we repealed Article 158, that now the president has the power to dismiss the DPP because there's no proper, channel or mechanism to remove him or her from office?
As you say this, there's two trends that I detect. One of the challenges we've had has been around the police and maintaining the protection for independence of the police. Right now, the way in which the current senior-most office holders in the National Police Service were appointed did not actually follow the constitutional requirements. There was a lot of attempts initially through attempts, I think, to enact the National Security Act and make changes there and, make changes to the Police Act and in a way basically undermine the role which the National Police Service is supposed to play. And then if you recollect, the earlier version of this bill had put in place a mechanism whereby the police would now be answering to a member of the cabinet. And because there was such an uproar about it, that provision was removed.
But I actually want to ask, when you've mentioned that, I noticed that when you go to page 23, they're proposing to amend Article 255, which talks about functions of the IG, to give the IG additional functions, which is to exercise independent command over the service, but also to determine promotions and transfers within the service, to exercise disciplinary control through suspension of officers, and to also perform any other functions prescribed by legislation.
Now, the older draft had then made the AG somebody under the IG somebody under the supervision of a cabinet minister.
Right.
So it would essentially have meant that the IG can then be instructed by a cabinet minister to undertake those. So that's the bit which has been changed.
Is there, I don't know, if the IG then has these functions, and if you look at this proposal on page 23, when you look at number 67, which also proposes to remove a function of the National Police Service. And
Commission.
The National Police Service Commission.
Exactly.
Which is the confirmation of an appointment, determination of promotions and transfers. So that is taken to the IG.
Yes.
What is the implication of that?
To me, first of all, you're stripping the National Police Service Commission of its primary functions. You're taking what is a collegiate responsibility and placing it in an individual. The National Police Service Commission, as a constitutional commission, enjoys certain protections that would have helped to insulate the police service from political interference. And so what I was going to observe generally is that you see an attempt to place all the law enforcement agencies under direct control of the executive in ways in which they were not. And these are actually changes that have implications in terms of the independence of those institutions. Now, in addition to this, it doesn't just apply to the law enforcement agencies. When you couple this with the fact that the cabinet ministers are no longer going to be vetted and are no longer impeachable. So they're appointed and they serve basically at the pleasure of the president.
So you risk, I'm assuming you're saying that someone like the Interior Minister then can become very powerful.
Not just the Interior Minister, your president has basically all the vast majority of the checks on the president have been removed.
Bobby, I wanted to ask you, when you were, during the COK 2010 process, and before that, what was the thinking behind, having something like the National Police Service Commission, and how did you think about the functions of the IG, the DPP, those offices?
One, there's been a long history. There was a long history of, how would I say, our police officers serving under deplorable conditions. And one reason was that they were directly serving under the pleasure of the executive. To a large extent, they still do, but with the commission, with the National Service Police Commission, that was more of an independent institution that would be in charge of one, determining the service terms, who gets to be hired, who gets to be fired, issues of discipline, but more importantly, also welfare issues. And so that's why Kenyans felt that instead of having this very important and to an extent specialized security organ under the terms or serving under the terms of the executive, and particularly the minister in charge of the operations, it would be better to have a commission that would look into these issues independently. You remember, there's also the philosophy that the change of the approach, that we are now moving from the police being looked as a force, as was historically and from the colonial days looked at, that you have the police to be in charge of the natives, of Africans, and to put them in line. That was the focus. And that went on since independence. And when Kenyans were giving their views to the Guy-led Commission, including institutions themselves, when you look at the final report of the Guy team, you see Kenyans asking for a big change in terms of reforming the police force as then was to be a service-oriented institution. And so some of these pronouncements, even in terms of the command structure, the police force and a commissioner was even in line with the international standards. There are also views from the police themselves, and they presented such technical advice that in line with international standards, and also in terms of terminology of command structures, where the police as a commission and the commissioner, that was outdated. And the seniority of police officers actually starts with the terminology of inspector. You know, once you get to an inspector and then you rise. So a lot of it was one to, in a very, I would say, dramatic way, indicate the change from what we had before. The police as a force to being more of a community-oriented service-providing institution. As I say, a breakaway. So the terminology, besides being in line with international standards, besides being in line with the policing, modern policing organization, was also very much indicative of that change. But the commission was very much to one break away from that direct political running of this institution. And as it was previously, you'd find it's the president or the minister in charge would even give directions to individual police officers. But also the police, as I was saying, the officers themselves that come up, and there are so many complaints, you know, even promotion. There isn't a defined criteria as to how you get promoted. So a commission would be able to independently and professionally look into these issues without interference from the political arm of running things.
So, but they're not proposing to remove the commission. The commission remains, but this one function is removed. Does it make a very big difference?
But that is the most important function that commission serves. So it has been hollowed. What is the, let's just look at what the police, National Police Service Commission does.
Currently, or as proposed?
No, currently.
Currently, that's Article 246.
Article 256(3) of the Constitution lays out the three functions of the National Police Service Commission.
So I'm actually looking at the job of the commission.
Can I read it for you?
Yeah.
A, recruit and appoint persons to hold or act in offices in the service, confirm appointments and determine promotions and transfers within the National Police Service. B.
So determine promotions and transfers, under this gets moved.
And you remember there's been a big fight since 2013.
So the commission still recruits and appoints people to hold in the offices of the service, but they do not confirm appointments and determine promotions and transfers. That is what is being
They don't
proposed.
determine promotions and transfers.
Right.
They confirm, but that has been taken away. The latter bit has been taken away.
And you know, the promotions, again, going back to what we were saying yesterday, we must look at this with the immediate experiences and history. And there have been big fights around, especially at the IG level, the senior, I think from the assistant inspector general to deputy, I think that's how they rank, assistant, then deputy. And so whenever, right from the fact that there was the lady who was supposed to take over from Kimayo, I think, she was next in, and then she was just...
And then they decided from then on not to have women at all in the
So
command.
I think,
So now IG has this power, would have
and
this mandate.
IG's power is is the minister's power. So
It's not just that. Now, when you look at this amendment, the only thing that the Police Service Commission will be doing is recruiting. That's it. That's all that's left. They've been hollowed.
When you go to the next page, page 24 of the bill, there is also a proposal to delete one paragraph in Article 246, which I think is also set and regularly review the conditions of the service and code of conduct within the service. That is being removed as a function of the National Police Service Commission. So they'll
be doing nothing. Their job is they're now a recruitment agency. Yeah. For the police.
Thank you. I just wanted a clarification.
The amendment bill, which is now popularly referred to as the BBI Amendment Bill, can be a difficult document to understand. So here's how you can read and understand the bill all by yourself. Print out the amendment bill as well as the Constitution of Kenya of 2010, read a proposal in the bill, and then counter-check with what the Constitution says about that specific article. For example, on page 5 of the bill, there's a proposal to amend Article 98 of the Constitution. The bill proposes deleting paragraph B from that article. Of course, you wouldn't know what that means unless you checked Article 98 of the Constitution of Kenya. Article 98 of the Constitution talks about the Constitution of the Senate, and that specific clause, B, talks of the 16 women senators nominated by political parties. So deleting this clause means that we would be eliminating the nominated senators as we currently know them. Whether positive or negative, this is a significant proposal. So keep the two documents close and scrutinize each proposal carefully.
I wanted us to go back to the judiciary briefly. We spoke about the tenure of the judges being changed, but on page 14
of the bill,
page 14 of the bill, proposes matching the tenure of office of the Chief Justice to the Deputy Chief Justice. Is there an implication to that, or does that make sense? I mean, the CJ and the Deputy CJ should basically serve the same tenure. Let me go to Bobby first.
Basically, only this afternoon I was answering a question to do with the media, somebody to do with since Maraga is proceeding on terminal leave today.
Right. So what is the implication of this? What are we saying?
It completely defeats the purpose of having a DCJ. The purpose of having a DCJ is so that when you don't have your CJ, because at some point in time your CJ will go away. CJs are human beings. They may, heaven forbid, drop dead. You have automatically somebody in place who can, until there's a substantive holder of office, hold that position. Since the new constitution came in, one of the things that the politicians have done is make sure that the CJ that is in office at the time an election happens, that no CJ presides over two elections.
Yeah.
It's been deliberate. They deliberately pick somebody who must retire
just before
an election. It is the one arm of the state where people are not as uncomfortable with people being old. There's nothing, as long as they're not suffering from any mental health issue, there is no problem, that would somehow interfere with their work. There is no problem with having an old judge. Look at Ruth Ginsburg. Yeah, how old was she?
But what if the promoters then use that reasoning to say that is actually why we're increasing the number of years you need professionally to be a CJ, a Court of Appeal judge, a DPP, the older the better.
But again, it's a 5 years and then you mature within within that service. I mean, that could be an argument.
It's a lot of information to unpack, and even our experts have had to go back and forth to find all the legal implications of some of the proposed amendments that touch on the judiciary.
Down in the tent, and then we were introduced.
So what happens when we get to debunking the proposal, which has been celebrated as a big win for Kenyan women? Perhaps the answer to the gender role debate. 47 women senators, county governments with gender representation. Could the BBI proposers have nailed the question of inclusivity in Kenya? That's on the next episode.